Thank you, counsel. Next case is Shepherd versus Deutsche Bank.
You said that wrong.
Please, the court, counsel, Wayne Klinkbiel of Foster & Klinkbiel on behalf of Heather Shepherd.
Could you speak up a little for me?
Sure. Wayne Klinkbiel of Foster & Klinkbiel on behalf of Heather Shepherd. I would respectfully request that 5 minutes be reserved for rebuttal.
All right.
We're here today on a civil case, and it's two straightforward issues arising out of the ruling of the trial court as it pertained to Ms. Shepherd's motions for entitlement to prevailing party attorney's fees after a voluntary dismissal was taken by Deutsche Bank pursuant to Rule 1.420, and also a motion to tax costs pursuant to 1.420 subsection D, to the extent that we believe that the agreement in place, the promissory note, and the mortgage both define costs to include attorney's fees, and as held by the Supreme Court in Rose v. Wilson Printing. This is the second time this case has been appealed. In the first appeal, the court reversed as it pertained to Heather Shepherd, finding that the service of process was void. The appellate court reserved ruling as it pertained to appellate attorney's fees until there is a prevailing party on the merits, is what the court indicated in its order. When we went back down to the trial court in front of Judge Stroker, instead of motioning the court to extend the time for service of process under 1.070, the Deutsche Bank chose to go ahead and file a separate and distinct cause of action, and a re-foreclosure, if you will, asserting the same foreclosure cause of action that was in the original underlying case that we're here for today. And it's our position that once they chose to take the voluntary dismissal, then the general rule, as set forth in the 5th District Court of Appeal opinion of Videbor, and followed up by Muniz, Videbor pertained to a voluntary dismissal with a statutory attorney fee prevailing party provision, wherein the court determined that once the voluntary dismissal is taken, the defendant becomes the prevailing party entitled to the statutory attorney's fees. Thereafter, in Muniz, the same issue was addressed as it pertained to a contractual attorney fee provision, and the Fifth held that the general rule applies and the defendant is the prevailing party. The trial court refused to entertain any argument as it pertained to attorney's fees and focused solely on the appellate order indicating that that fees should not be entered until there is a finding on the merits. We attempted to argue that that rule was, in essence, mooted by the actions of Deutsche Bank. Had they tried to move under 1.070 to extend the time for service of process, subsection J of that rule indicates that if that motion is then denied, then the defendant would not be the prevailing party, and you would not be entitled to prevailing party attorney's fees. You would not be entitled to 1.420 attorney's fees and costs. That wasn't done. In essence, what Deutsche Bank did is they took the cards that were on the table facing the trial court, took them off the table, shuffled the deck, and redealt a new hand. And because of that, the issues are very straightforward. To the extent that they entered a voluntary dismissal, then the general rule applies. Heather Shepherd becomes the prevailing party. In addition, as I indicated before, the promissory note indicates specifically, if the note holder has required me to pay immediately in full, as described above, the note holder will have the right to be paid back by me for all of its costs and expenses in enforcing this note to the extent not prohibited by the applicable law. These expenses include, for example, reasonable attorney's fees. The mortgage, in similar words, lender shall be entitled to collect all expenses incurred in pursuing the remedies provided in this paragraph 21, including but not limited to reasonable attorney's fees and costs of title evidence. Now, understand that that is an attorney fee provision solely for the lender. But Florida Statute Section 57105 comes into play with the reciprocal attorney fee provision, and the cases interpreting that, as it first came out, it was subsection 2 and then it moved on to subsection 5, and currently now it is subsection 7 of that rule. In Landry v. Countrywide Homes, the appellate court in that particular case indicated that the reciprocal provisions of 57-105 are now mandatory. And I did find a 5th District Court of Appeal opinion, Holiday Square Owners Association versus Setsenis, Tsetsenis, that I did a notice of supplemental authority this morning. That's cited at 820 Southern 2nd, 450. It's a 2002 opinion from the 5th that references the Landry opinion and also makes a determination that the 57-105, in this particular time it was subsection 5, that is a mandatory reciprocal provision. To the extent that the trial court failed to take into account the written contract that was in place, indicating that the prevailing party would be entitled to their reasonable attorney's fees, and the interplay of 57-105 and the reciprocal provisions, the trial court failed to exercise the agreement. In a Jacobson v. Jacobson, which is another 5th District Court of Appeal opinion, there was a mediated settlement agreement between the husband and the wife, and motions were heard in the trial court, and the wife prevailed. And there was a provision in the mediated settlement agreement that to the extent that any motions need to be heard thereafter, the prevailing party would be entitled to their fees. And the trial court denied the wife's motion for the fees. And on appeal, the 5th District indicated that the court has no discretion. If the agreement indicates that you have to award fees, then fees are awardable. You cannot rewrite the contract. And in this particular case, the court just didn't rule and refuses to rule until there's a resolution of the refiled action. And the refiling of the reforeclosure, if you will, really has no bearing on the issues before the court now. Because of the general rule, once you take the voluntary dismissal, the defendant becomes the prevailing party. Whether there's a prevailing party on the merits is not required. And that's set forth in the Thornburg opinion with the Supreme Court, and thereafter Boca Airport, which made reference to Stewart Plaza and Gordon, in essence saying that once the voluntary dismissal is taken, the defendant becomes the prevailing party. Stewart Plaza is a contract case, and Gordon is the mechanics lien statute. There are also additional cases that say there is no requirement for an adjudication on the merits that are cited in the brief. That's the Alhambra opinion, which is actually interesting to the extent that Alhambra was a case that there was a refiled cause of action, and the appeal in that particular case was that they were seeking costs after the voluntary dismissal. They ended up losing in the second case. But the appellate court said that doesn't matter because all we look to is the voluntary dismissal. And there doesn't need to be a prevailing party on the merits. We apply the general rule. To the extent that there was a dismissal, this court has actually already held that in a foreclosure action, when a voluntary dismissal is taken, that the defendant is the prevailing party, and that is the Heidel versus S&S Drywall opinion, where the court actually indicated that when you sue for a foreclosure, the significant issue in a foreclosure cause of action is foreclosure. And to the extent that a dismissal was taken pursuant to 1.420, foreclosure did not occur, therefore the defendant is the prevailing party. The significant issues test is that set forth by the Supreme Court in Moritz. So no matter which way you look at it, whether you needed a prevailing party or not, Heather Shepherd is the prevailing party because of the voluntary dismissal. We also moved under 1.420 to the extent that the agreement defines costs to include attorney's fees. And that's the Wilson versus Rose printing opinion. And I quote from that opinion, "This court has consistently held that where a statute or agreement of the parties provides the term costs includes attorney's fees, such fees are taxable under Rule 1.420D. The parties agreed that costs included reasonable attorney's fees for any litigation arising out of the agreement. That no prevailing party has been determined is irrelevant for our inquiry, since it is Rule 1.420D, not the employment agreement, that entitles Rose to seek costs here. We look to the agreement to define costs, not to determine the circumstances under which costs may be awarded." The trial court did award costs, but the trial court only awarded the cost as set for incidental costs, deposition transcripts, things like that. To the extent we sought attorney's fees as an element of cost, the court refused to do that. And then once again indicated that it was going to wait until there was a rendition of a ruling in the second case. And that's just not what the law is. in Caulfield v. Cantil, which is a Supreme Court opinion that came out of the 5th District Court of Appeal, this exact issue was addressed, and the jurisdictional issue was addressed in that opinion also, to the extent whether plenary appeal was the proper avenue in which to pursue a denial of attorney's fees as costs not pursuant to 1.420. And Caulfield analyzed all of the competing concerns and determined that plenary appeal is the proper avenue, that a defendant is entitled to a rendition of a ruling in that case at that time, and that the refiling of another cause of action is irrelevant to that analysis. And they also recognize that the rule 1.420 itself also takes that into account, that to the extent that if there is a refiled cause of action, then if the plaintiff in that particular case prevails, then they have the ability to motion the court in that particular proceeding as an element of their cost, the costs that were paid in the first case. The court just would not even entertain any argument as it pertained to fees, and specifically said, take it upstairs. And that's what we're doing here. The contract provides for prevailing party attorney's fees. 57-105, subsection 7 is a mandatory reciprocal provision. 59.46 is the appellate attorney fee rule that indicates if you prevail, you're entitled to your attorney's fees. And I've cited some Fifth cases that say to the extent that you're the prevailing party down below, then you're also deemed to be the prevailing party on appeal. And to the extent that they've taken the voluntary dismissal, we're the prevailing party. To the extent you apply a merit significant issues analysis to the case, it's a foreclosure cause of action. There is no foreclosure. We prevailed on the significant issue also. No matter which way you look at this case, Heather Shepherd is the prevailing party. And when you look at the contract indicates that those fees shall be awarded. And you couple that with the statute, 57-105, that makes it reciprocal, then it's mandatory. And it would be our position that to the extent that the trial court failed to assess the fees as required by the contract, that would be a de novo review for this court, which I also set out in a supplemental authority motion, which was T&W Developers versus Ray Salmonson, which just came out of this court on April the 1st, I believe, which said 2010 Westlaw 1233481. And that opinion also references merits, that to the extent that you make a prevailing party analysis, you need to look at the significant issues. And you need to go back to the Heidel opinion that says significant issue on foreclosure is foreclosure. And there is no foreclosure in this case. Thank you. I'd respectfully reserve the remaining time.
Thank you.
Good morning, Your Honors. Priscilla Maxim Armand for the appellee, Deutsche Bank. Now, as counsel pointed out, this was initially a foreclosure action. There was a first appeal, and there was a judgment was rendered, and the court found that judgment had been properly obtained against the husband, Nigel Shepherd, but they reversed as to the appellant, Heather Shepherd, based on improper service.
Essentially, you're arguing that this court should accept the rule of law set forth in Simmons versus Schimmel, correct?
Correct.
Right. We rejected that in prior cases. If you'd like, just take a very short amount of time to argue why you think the rejection of that law was incorrect.
Well, I think in this case, it wasn't a voluntary dismissal under, and it's a very fine line, I understand, under 1.420A1. It was a drop under 1.250. Heather Shepherd there was already a final judgment that was obtained when the first appeal came up. It was obtained against both of them. When it was reversed as to Heather Shepherd, she was there were then 2 cases going against her. So there was a motion to dismiss her from the one case, and then the re-foreclosure action, as it's titled, continued against her. So for one, you're dealing, I think it's a little different in that you're dealing with a drop. Also, in the Schimmel case and in other cases where the court declined to follow Schimmel, there was no pending re-foreclosure action. It was either dismissed with prejudice, or because there was a second dismissal taken, the action couldn't be refiled. So I think those are the 2 main differences, and the reason why that this is a different case, and why the court should find that there need to be a prevailing party on the merits in order. And I think Schimmel too said there must be some sort of end to the litigation on the merits. There need not be formal merits determination. And I don't think that in this case, there was also the order from this court saying that the party had to prevail on the merits in order to be entitled to attorney's fees. So the judge in the lower court was ruling based on that order, and also in finding that the defendant was not the prevailing party on the merits, and therefore not entitled to attorney's fees yet. Also, the court, the trial court...
Is there any reason that Deutsche Bank couldn't have simply reserved?
Well, I think the time for service was gone. They could have...
You're talking about the 120 days?
They were way outside the 120 days.
All right, well...
Or you could have moved to consolidate the 2 actions.
The 2 actions in one, but I think they were... they were pretty much the same action. So maybe that was an option, but I think it was procedurally what was happening is that one of the cases had to be done away with because you were proceeding against her with pretty much the same case. So I think in this case, based on the order and also based on the note which the counsel pointed out, only provided for attorney's fees for the appellee, Deutsche Bank, and 57105 does have a reciprocal provision. It's our position that the standard of review in this case is abuse of discretion, and that the trial court did not abuse its discretion since 57105.7 has that provision that says the court may allow reasonable attorney's fees to the other party. And when the court declined to award attorney's fees to the appellant until there was adjudication on the merits, they were following and it could be interpreted, they were following the statute which gave them discretion as to whether or not to award attorney's fees. Also, in appellant's brief, they're asking for attorney's fees that the court, in the trial court rather, should have awarded attorney's fees even though the appellant was not the prevailing party on the merits. However, I think because there is that order that existed that stated that attorney's fees were provisionally granted should the appellant prevail on the merits below, that the trial court could not have awarded attorney's fees to the appellant in that for their appellant attorneys for the appeal. So we're also the appellant cites to Thornburg versus City of Fort Walton Beach for the general rule that when the plaintiff voluntarily dismisses, the defendant is the prevailing party. However, as stated before, it's our position that this is actually a drop. It's not really a voluntary dismissal. And also, Thornburg is factually dissimilar from our case because in Thornburg, the dismissal was with prejudice, and in this case, there is still this pending re-foreclosure action. Therefore, we would ask that the court affirm the trial court's order, and which in essence was deferring on ruling on the award of attorney's fees until there was an adjudication on the merits.
How would the trial court, after this action had been dropped, you dropped this particular party, which had the effect, since the case was otherwise concluded, of closing out the case? How would the trial court, a year later, 6 months later, have jurisdiction to come back and award fees in this action if it turned out that they prevailed?
Well, I think the prevailing party attorney's fees could still be awarded if they prevail because there is the pending re-foreclosure action. So if in that action they won the...
Do you think in action number 2, if they win, the court would have the authority to award fees that were incurred in action number 1?
I think that first it would be our position that they wouldn't be entitled to fees in action number 1. I think procedurally probably the court could not award fees in action number 1.
Well, no. I'm assuming if they prevail ultimately in action number 2, what authority would the court then have to come in and award fees in action number 1?
Well, I think if they were ordered to do it by this court, they probably could award attorney's fees in action number 1. But like I said, I think it's our position that she didn't prevail in action number 1 when she was dropped. You know, she should, if she prevails in action number 2, then she would be entitled to attorney's fees.
For action number 1 or only for action
Only
number 2?
for action number 2.
So she strikes out no matter what your view is that as to fees in action number 1, she's just out of luck. She doesn't get fees one way or the other, irrespective of the outcome of action number 2.
Right, because it's our position that she didn't prevail on the merits, which was the requirement.
And that's because you drop a party and dismiss an action. Because you dropped her, or because the dropping of the party doesn't constitute an adjudication on the merits?
The dropping, at least our position, does not constitute an adjudication on the merits. Even a dismissal does not constitute an adjudication on the merits. I think the cases that deal with a dismissal state that it's a prevailing party. It's a question as to whether she's the prevailing party and entitled to attorney's fees. I don't think, and also counsel cited to a case that talked about being the prevailing party on the significant issues. The significant issue is the foreclosure. There hasn't, the foreclosure isn't concluded yet. The foreclosure is still pending in this re-foreclosure action to foreclose out her interest in the note and mortgage.
It was concluded in that case.
Well, but like I said, I think it's because it's a unique situation, because there is the cases that have found that the litigation is ended. There isn't. It's either dismissed with prejudice, or there was there's no indication of refiling. Here we do have that pending foreclosure action. So, you know, it's a different situation, I think, than those cases that counsel cites to. I think that's...
Thank you, counsel. Mr. Klinkweil, do you have anything further?
Yes, sir. Yeah, please,
Further in the way of rebuttal, not to simply restate what you've already said.
I understand. As it pertains to the question pertaining to Deutsche Bank's request that this court apply the Schimmel approach, and it was Judge Cohen that referenced that the Fifth has rejected that. That was in Vidibor. It was specifically rejected. In addition, the Supreme Court addressed the issue in Wilson versus Wilson versus Rose painting, to the extent that Vidibor was a construction of a statute and Schimmel is the construction of a statute. In Rose, the Supreme Court limited Schimmel to the setting where you're construing a statute, and to the extent in Rose that they were interpreting a contract, the Supreme Court indicated Schimmel has no approach here. We have a contract before us here today. Okay. To the extent that counsel has argued that because there's a reforeclosure action, that this is different than the other cases, well, there's a litany of cases we cited in our brief: Marsh versus Doran, Caulfield versus Cantil, the Frazier opinion in the Bank of New York versus Williams, which is actually a mortgage foreclosure case where the court determined where there were refiled causes of action. Alhambra also, it's irrelevant whether it's refiled or not. And you need to take into account Caulfield to the extent that it indicates that you're entitled to a ruling in this particular case now. And to the extent that the court has pointed out that this case is over, that's exactly what McKenzie versus Kismet says. Once you file that voluntary dismissal, and a voluntary dismissal pursuant to 1.420 was filed, this case is over. To the extent that Deutsche Bank argues that 57105 can be interpreted to be discretionary, I believe the Landry opinion and also the Holiday Square Owners versus Tetsenis 5th DCA opinion is squarely on point and indicates that it's a mandatory reciprocal provision. So that's just not correct. To the extent Judge Orfinger inquired how would the trial court have jurisdiction in this particular case pending the resolution of the second case, that is also an issue addressed in the McKenzie v. Kismet, wherein the court held the first case is over, you're done, you deal with it now. And that's codified in Caulfield v. Cantil, that you need to do it in this case, in that particular opinion. And that goes to Judge Cohen's question also as it pertained to the refiling in the second case. McKenzie v. Kismet says that the jurisdiction is in that particular case. It's not in a separate case. Jurisdiction is in this case number, Shepherd number 1. And no matter which way you look at it, Heather Shepherd is the prevailing party based upon the voluntary dismissal, based upon the Moritz significant issues, and based upon the Heidel versus S&S drywall opinion where foreclosure was filed and voluntary dismissal was taken pursuant to 1.420 and the defendant was deemed the prevailing party and entitled to prevailing party attorney's fees. Thank you.
Thank you, counsel. Well argued.